Good afternoon. This video lecture is going to include chapters 4, 5, and 6. I hope to kind of squeeze this in within an hour or so. So that's the plan. As a reminder, I would suggest that you print out the 4, 5, and 6 PowerPoints out of the module 1, and then follow along on the lecture because that's what the lecture is based off of. You could use your printouts to highlight areas that you might want to go back and refer to later on for the purposes of study for the exam or for the other assignments within the module. All right, so let's let's go on. We're talking about what corrections is for. So the primary purpose we learned of corrections was punishment. There was actually twofold, but we're going to be focusing on punishment specifically for this slide here. And then we have to kind of decide what punishment means. So there's 3 elements to punishment. The offense, the infliction of pain or discomfort because of the commission of the offense, and to prevent further offenses from occurring or to inflict deserved pain on the individuals that commit the crime. And so those are the elements of punishment. But there's 5 goals to these punishment or criminal sanctions, right? So there's 5 major goals. These 5 major goals they use the term goals, but in actuality, they're mechanisms for punishment, right? And so the first one is retribution, and then that's what the primary purpose is. That's the infliction of punishment on a person who's infringed on the rights of others and deserves to be penalized. And in our society, we have the penal code. Deterrence is another goal, convincing the public and the offender via punishment that crime doesn't pay. So the concepts of general deterrence and then specific deterrence fall under that category. The third one, the most widely used, is incapacitation. That's depriving a person of liberty or freedom, reducing their abilities to commit crime. And we learned earlier on that process is by incarceration. The fourth one is rehabilitation. That's the goal of restoring a convicted person's constructive place in society through vocational education and or therapy programs. And we have a number of those that are in place now. And the fifth one is the most recent one that we started to adopt into our criminal justice system, and that's restoration. And restoration is a punishment of the offender designed to repair the damage done to the victim and the community. So the focus there, as opposed to like incapacitation, which serves to protect the public first, rehabilitation serves to help the offender, restoration focuses on the victim and society as a whole. Okay, moving on to slide number 2. Determinate and indeterminate sentences for incarceration. As of 2015, 1.5 million Americans are in federal and state prisons, and that's throughout the United States. Incarceration, again, is the most widely visible penalty imposed by the courts, and there are 3 basic sentencing structures, and we've talked about those: indeterminate sentences, determinate sentences, and mandatory minimum. And remember, as a review, if you look at the 2, indeterminate and determinate, you can kind of equate those over to mathematics, where an indeterminate sentence would be a ray, so it would have a start, but potentially no end, well, at least until the person expires in custody. Determinate sentencing would be a line segment, and then mandatory sentencing. So we're going to go through all those. The first one, indeterminate sentences based on the goal of rehabilitation. They have a minimum and maximum sentence length prior to parole eligibility. Sometimes they don't have that maximum sentence length. It can be up to life. And that's based on the offender's behavior while they're in custody. So an example of an indeterminate sentence would be 2 years to life, right? What it does, it puts the onus of responsibility back on the offender, so they behave while they're in custody, and their behavior engaging in programs and not and refraining from violation of rules allows them the opportunity to be granted conditional release, which would be called parole, and to finish off the remainder of their sentence in community corrections. Determinate sentences, the next one, are fixed periods of incarceration imposed by the court codified by law. They are based on retribution and deserved punishment. Presumptive sentences, which fall under determinate sentencing law, are sentences that have a minimum and maximum range where the court takes into account mitigating aggravating factors of the crime and the offender and uses those when they factor in the sentence. So that's what we currently have here in California, and believe it or not, the bulk of the United States utilizes determinate sentencing. And they were talking about mitigating aggravating factors when they get to the sentencing portion. If you have two individuals that had similarly situated crimes, yet different social behavior, educational data, as well as a criminal history that was completely different, the likelihood is high that the individual that has less root in that community, as well as a higher level of criminality, will likely get the higher level versus like a first-time offender or a low-level offender. And then the last one is mandatory minimum sentences, or mandatory sentences, are sentences that stipulate a minimum period of incarceration regardless of the background of the offender or the circumstances of the offense. An example would be like the 3 strikes law, and that's pretty self-explanatory. Just FYI, here in California, there is a moratorium with regard to 3 strikes. And even though you can still be sentenced under these mandatory minimum sentences, the Department of Corrections cannot impose those sentences. So say, for instance, a person had an enhancement, a 667.5C, that enhancement, that mandatory sentence, even though it's recognized the way that moratorium is or the way that law is, they're not authorized to do that, which is, in my personal opinion, is a problem, because there were these mandatory sentences were designed to act as stiffer penalties, as well as specific and general deterrence, so people would be less apt to want to do them because they know that those specific crimes carried a much higher penalty based on those enhancements, based off of the mandatory sentencing. All right, moving on to slide number 3, intermediate sanctions. So remember, we talked about the continuum of sanctions, or the continuum of punishment or corrections. At the low end, we talked about probation, which is community corrections. And then we move to intermediate sanctions, which we're talking about now. And then, of course, we move over to incarceration. So in intermediate sanctions, there are a variety of punishments that are less restrictive than incarceration over here, but more restrictive than general probation, which is over here, right? Some examples include intensive supervision probation, which would include specialized caseloads such as gang members or sex offenders. And that intensive supervision means that the supervising officer or the monitoring officer or agent will actually be the person who is sees that offender more often and has more conditions in their community release than somebody who would be on general probation. Inpatient substance abuse treatment programs, boot camps. The boot camps are military structured residential programs used primarily for supposed to be youthful offenders, and halfway houses are residential programs such as work furloughs. So there's a number of different programs that are used even within the corrections continuum. So remember, we can move our offender up and down that continuum. To use an example of a halfway house, back when I started with the Department of Corrections and I was a correctional counselor, right around, I would say, late 1990s to the 2000s, the early 2000s, we used to have individuals that would be in custody, or they would be in they'd be in prison. And if they did what they were supposed to do within a period of time, within, like I want to say it's like 6 or 9 months from their release date, from their EPRD, they could put in a request to move to an intermediate sanction, to a work furlough program, which would basically, they were still in custody, but they would move them into a CCC, which is a community correctional center, work furlough, where they would have an opportunity to obtain employment. And then part of that employment, that money would normally get split 3 ways. 1/3 would go to the offender, 1/3 that they had immediate access to, 1/3 went into a savings account for the offender. So when they did finally parole, they would have a little bit of money saved up where they could, maybe buy a car or do whatever they needed to do. And then, of course, 1/3 would go back to that program to help fund it, so that way the funding would stay there. In my opinion, work furloughs were probably one of the better programs, and unfortunately, California got rid of them, which I thought was a really bad idea, but what do I know? Community service is usually coupled with restitution and fines. which are another intermediate sanction. At times, house arrest, to include GPS, electronic monitoring, will be used to monitor offenders assigned to this sanction. And then probation is the lowest level, and it really doesn't fall under intermediate sanctions, but they're the lowest level of supervision, community supervision, that allows an offender to remain in the community while under supervision, usually with conditions of release assigned by the court. At times, the court will opt for a split sentence, sometimes called shock probation, where the offender serves a period of time in custody, then released to probation supervision. And they do that a number of times with first-time offenders to give them a taste, essentially, of what it would be like when they were incarcerated, and that shock of being in jail sometimes has the desired effect of saying, if you violate your probation, we're going to put you back over here. And they're like, I don't want to go back there. And so that is the reasoning behind shock probation. So there's a number of different programs, and that's just a small list. Believe it or not, there's quite a few more that are available with regard to the sanctions, the continuum of sanctions. So, but this basically covers the bulk of all the intermediate sanctions. All right, slide number 4. Felonies. All right, so of all felonies committed in the United States, 41% result in a prison sentence, 28% in a jail sentence, and 27% result in probation or parole. That's a little bit different here in California. Believe it or not, California actually has a significant amount more going to jail and a little bit less going to prison. That's as a result of AB 109, Prop 47, and Prop 57. Now, some of you may wonder, how do some people go from committing that felony, get sentenced right to parole? Well, there are some instances where a sentence, the person was in jail going through their trial process, and if their sentence was, say, 1 year, 4 months, they had good conduct credits while they were in the jail. If their sentence was 1 year, 4 months, and it took a while for that trial to go through, there are instances where the entire trial period, at the time that they were serving in custody, would have exceeded or matched their period of time that they would have been actually in custody should they have been sentenced. So as opposed to sentencing them because they've already served all that time, they essentially move right to parole and become being supervised on parole. Now, prior to AB 109 and Prop 47 here in California, if an individual was sentenced to parole, what would likely happen is if they violated that parole, they would get sent to prison for that revocation period. However, now, with those two laws in place, they get sent to county jails. That's where the revocation, their incarceration sanction for revocation is completed at. Now, revocation essentially is having parole revoked and a person going back into custody. So, violent felonies, 54% result in a prison sentence, 23% in jail, and 20% go to probation. And remember, we spoke about probation being a relief valve of sorts. That's one of the mechanisms that courts use, and so they get all this data from the different areas of incarceration, jails and prisons. And the courts, it gives them a little bit of information and latitude. And there's some instances where some violent felonies, even though it's not really desirable, but some violent felonies do get probation. Property offenses, 38% are sentenced to prison, 29% to jail, 29% to probation. And drug offenses are similarly situated, although 28% are sentenced to jail and 30% are sentenced to probation. You will probably see these percentages again in your exam, so make yourself, comfortably aware of them because you will likely be tested on your knowledge of the breakdowns of felonies in relation to prison, jail, and probation. Okay, number 5. After finding of guilt, the judge has a responsibility to render a sentence, the pre-sentence report, and that's generated by a probation officer. It's called a POR, or the pre-investigation sentence report. You could hear either one of those two. That report summarizes the circumstances of the offense, the offender's background, their demographics, the victim's statement, which is really important, along with a recommended sentence based on codified guidelines. Now, just FYI, you would think that most judges, when they're looking at sentencing kind of decide on their own what they're going to wind up doing. But believe it or not, about 95% of all recommended sentences by the probation departments are essentially rubber stamped by the judge. So that just goes to show you the level of expertise and the thoroughness of these reports, plus the overall respect that the court has for the probation departments is it's pretty telling with regard to how much the courts agree and actually impose the recommendations by probation. Sentencing guidelines are codified rules that are developed for judges to aid them in sentencing. Sentencing guidelines have been adopted in the hope of reducing disparity in sentencing for similarly situated offenses and offenders, to establish truth in sentencing, and to reduce prison crowding, and to make sentencing more rational. So sentencing guidelines are essentially, well, here in California, they're covered under Title IV, and Title IV essentially tells judges that if these set of circumstances exist, then you need to sentence in this range. If these set of circumstances exist, then you need to sentence in this range. And if another set of circumstances exist, then you sentence in this range. So the judge is essentially looking for all these circumstances surrounding the offender and the offense to make a fair judgment. So and the reason why they do that, again, is to establish truth in sentencing, so that way similarly situated offenses and offenders get similarly situated sentences. So there's a little bit of equity. Now, the drawback to that is, again, the rubber stamp circumstance, where judges don't have an opportunity to utilize their own discretion as much as they would if there was no sentencing guidelines. So and that becomes an issue in some cases where some people might have been given a little bit more. And I'll back up a little bit. Most of the time, sentencing guidelines in these large cities, they really follow them. But in some of the small cities, the judges or towns, judges usually will have a little bit more latitude with regard to their sentencing based off of the geography and demographic there. So in California, I talked about that a second ago, sentencing guidelines are established, codified, which is written down in the California Code of Regulations, Title IV. That title is California Rules of Court. For the purposes of corrections, and you will go through that a little bit later on, our regulations in corrections is California Code of Regulations, Title 15, and that's that kind of tells inmates as well as staff what their responsibilities are with regard to behavior and duties while they're working as peace officers and to a certain extent free staff, which are individuals that work within the prison system but are not peace officers, such as teachers and cooks and that kind of stuff. Okay, unjust punishment. So there's two types. You'll see this again. There's two types of unjust punishments. They are sentencing disparities and wrongful convictions. So we're going to start with sentencing disparities first. They are the divergence of sentence lengths and types imposed for the same crime or crimes of comparable seriousness without any reasonable justification. So they use an example here, and I'll give you one that's a little bit closer to home. The example here is sentencing disparity may have a higher proportion of African Americans and Hispanics having longer sentences for the same offense than Caucasian counterparts. This happened specifically with the sentencing of cocaine or possession of cocaine. So this goes back into the 1970s and early 80s. Some of you may have seen this movie called New Jack City. In New Jack City, they took essentially raw cocaine and processed it into rocks of cocaine, much like methamphetamine rocks. And this process allowed for the very inexpensive use of cocaine by the masses. So cocaine in the early 80s, late 70s, early 80s, was really an affluent drug. It was very expensive to process. It was very expensive to transport. And as a result of that, when it got to the end user, it was expensive to obtain. And as a result, the only people that would normally have cocaine were people of affluence. They would, and you'd see the wealthy yuppie kids of the early '80s who would snort cocaine, aka nose candy, and that's how it was ingested in sulfilation. And some of these kids had backgrounds in chemistry, and they learned that they can take this raw cocaine, rock it up for pennies on the dollar, and sell it. Well, now that allowed the poorer masses to have access to cocaine. That became rock cocaine, and that rock cocaine, you could buy one rock for about $5 or $10, and it became really popular. Well, the issue was sentencing with regard to that. So if you were sentenced for possession of cocaine and it was just powder cocaine, the likelihood is you'd wind up getting probation or a slap on the hand or maybe a diversion. However, people that were living in inner cities, especially African Americans at the time, who used rock cocaine, were getting substantially higher sentences. Upwards of 5 or 6 years for possession and or use of rock cocaine. And the truth in sentencing laws basically changed that to ensure that, because even though the end product was different in design, it was still overall the same product. And now powder cocaine as well as rock cocaine, possession of each one of them in similar amounts is going to yield a similar sanction. So people who were affluent, had a lot of money, that had powder cocaine, were less likely to get away with the punishment that their counterparts who had rock cocaine. Wrongful conviction is simply a conviction that occurs of an innocent person who is found guilty by either a plea agreement or a verdict. Many wrongful convictions have recently been overturned by the introduction of DNA evidence, which we now have the ability to decode, and most of these cases are for capital type crimes, crimes against person. All right, well, that concludes Chapter 4. We're going to move on to Chapter 5. I'm going to pause this for a second, and then we will go forward. Well, that's not working very well. Okay, so let's see. We'll just go forward to Chapter 5. Okay, on Chapter 5, we're talking about foundations of correctional law on slide 1. There are 4 correctional law foundations that protect the legal rights of inmates under correctional supervision. Pretty simple stuff here. State, federal constitutions, statutes, again, we learned that is written law, legislative law, case law, which is judge-made law, and then regulations, which are also legislative, but they are specific to government. So we'll kind of go through these. Constitution is a written document that contains state or federal law that limits government, codifies the basic rights of the individual. So those are enumerated for the federal government. They are enumerated in our Bill of Rights, and then California has its own constitution. Now, just FYI, because the Constitution is designed to limit government and to codify what is considered a natural right, state governments are obligated to follow the federal government constitution. They cannot make anything stricter than the federal government. So we have the right to peacefully assemble. The state cannot go and say, well, we're going to limit the right of peaceful assembly to, 100 people, whatever. And they can't do that because that puts a limit on something that the federal government already found. But in their constitution, they can grant additional rights. So something that is, or not want to say grant, but they can codify additional rights. They can make it softer, but they can't make it harder than the federal constitution, than the U.S. Constitution. All right, so statutes are laws created by the people through elected representatives in the legislature. Case law are legal rules produced by judges' decision, otherwise known as a precedent. A precedent utilizing case law as a guide for subsequent rulings by judges in similarly situated cases. And then regulations are legal rules, usually set by the legislature or government agency, up to the executive branch, designed to implement the policies of that agency, so that way they know how to behave and what they can and cannot do. Okay, so those are the four: state, federal constitution, statutes, case law, and then regulations. You'll need to know those. All right, moving on to number two, the Supreme Court of the United States. That's SCOTUS, and then correctional law. So in the 1960s, the courts maintained what's called a hands-off policy with respect to corrections. Most judges held that the belief that incarcerated individuals did not have rights. Hands-off policy is the judicial policy of non-interference concerning the internal administration of prisons. But then that changed with the United States Supreme Court decision of Cooper v. Pate. You'll see that again. This decision found that state inmates have rights under the U.S. Constitution Bill of Rights and could bring suit for violation of these rights to federal court. And that kind of signaled the end of the hands-off policy. The Supreme Court found that jailers that deprived an inmate of their constitutional rights could not only face civil liability, which would result in monetary compensation awarded to the inmate as a result of constitutional rights violations, but they could the actual officer could also face civil liability. So not just the jailer, not just the prison or jail or the state or the county, but the actual officer could as well. Habeas corpus, and this was the mechanism for bringing these cases to suit or bringing these cases to the court. Writs of habeas corpus, and that habeas corpus stands for you have the body, is a judicial order by the court demanding that an inmate be brought before the court so he or she can ask the court to examine the legality of one of two things, either their imprisonment or their sentencing, and to ask for release from legal confinement, right? So these writs of habeas corpus talked about specific sentencing and or the legality of their imprisonment. All right, slide number 3, prisoners' rights. Constitutional rights that are applicable to inmate rights include First Amendment, 4th, 8th, under the Bill of Rights. So the first, remember the Bill of Rights is the 1st through the 10th Amendment. And then the 14th Amendment, and we're going to kind of go through each one of these. Now, just FYI, while the courts did find in Cooper v. Pate that inmates are entitled to certain rights under the U.S. Constitution, they did find also that there has to be no criminological interest to deny that right. So in other words, inmates don't get, like there's one certain right we know they don't get. They don't get the right to peacefully assemble. And the reason why they don't get that right is because that would pose a safety and security issue to the institutions or jails or prisons or whatever whatchamacallit. So they will get to peacefully assemble inside the prison. There's rules against that, right? All right. So these limitations there are limitations to the First Amendment. The courts have found that the meaning of ensuring legitimate state interest, and in this case prison security, impose fewer limits on prisoners' rights than do alternative means of securing that end. This is called the less restrictive method. So additionally, compelling state interest is the interest of the state as such like security of prisons that takes precedence over the rights guaranteed by the First Amendment. I just told you one of the ones that they don't get access to. They cannot peacefully assemble. A clear and present danger is a threat to the security or safety of the individuals that's so obvious and compelling that the need to counter it overrides the guarantee of the First Amendment. And that would be one of the things that you can demonstrate easily with regard to clear and present danger. So if we allowed our inmate population, like what's going on in the news today, we have these riots that are happening as a result of the George Floyd killing. And as a result of that, if we allowed the inmates, we had one inmate who was speaking about this, and he had a whole crowd of people gathering around him. That speech could start ramping people up, and obviously we get these people ramped up. get emotionally charged, the likelihood is high that we're going to have violent confrontations within the prison. So that clear and present danger standard allows the Department of Corrections and the jails to prohibit that kind of behavior. In order to determine whether restrictions to the First Amendment protections are in the best penological interest, the Supreme Court developed a rational basis test. Now, you'll need to know this term, rational basis test, and that requires that a regulation provide a reasonable, rational method of advancing a legitimate institutional goal. So you can't, the Department of Corrections just can't make arbitrary rules because they just sound good, right? They have to have some specific legitimate institutional goal, a safety security issue, or the medical rights of people, or equal access. They can't just unilaterally say, we're not going to do this because we just don't like it, right? So that was what the Supreme Court decided. They said we need to have a test to make sure that if a regulation is imposed by the Department of Corrections, there is a legitimate institutional goal with regard to that regulation. All right, slide number 4. So First Amendment decisions, we're going to go through the amendments, and I'm going to note some of the case law. My suggestion to you is to become familiar. Some of these will be on your exam. So First Amendment, Congress made no law respecting the establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peacefully assemble and to petition the government for redress of grievances. So Fulward v. Clemmer, Gittlemakers v. Prossi, Cruz v. Bello, Procurner v. Martinez, Olone v. Estate of Shabazz, and Beard v. Banks. Those last two are decisions that the Supreme Court sided with the Department of Corrections. The former 4 are where the Supreme Court recognized the application of the rights that basically granted it for the plaintiff in that case, which would have been the inmates with regard to First Amendment decisions. So again, make yourself familiar with those. Slide number 5 discusses the Fourth Amendment. So the Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures that shall not be violated, and no warrant shall be issued upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, right? And so essentially that's talking about the government's ability to enter a person's home, and what steps that have to happen in order for them to do that. And so Lanza v. New York, conversations recorded in jail are not protected by the Fourth Amendment, and most of these are clarifications for the Fourth Amendment. In the United States v. Hitchcock, warrantless search of a cell is not unreasonable, and that's pretty much the same thing that happened at Hudson v. Palmer in 1984. Prison jail officials may search cells without warrant, seize materials found there. And then strip searches to include body search cavities after contact visits may be carried out when the need for such searches outweighs the personal right of the person being searched, and that institutional need would be institutional security. So those 4 cases set the precedent for Fourth Amendment issues with regard to institutional security. All right, moving on to number 6. Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Federal courts have ruled that some aspects of prison life don't violate individual rights, and the totality of conditions or circumstances may constitute cruel and unusual punishment. So Estelle v. Gamber, deliberate indifference to medical needs of inmates constitute a violation of the Eighth Amendment. So what deliberate indifference is, and I'm going to tell you that's probably going to be one of the frequently heard terms that you're going to have as a peace officer. And so essentially what it means is that when you have a set of facts that you know requires a certain action, that you turn your back on that responsibility for that action, and as a result of not doing something, you are civilly liable. So an example would be if an inmate had a medical issue. You had this inmate who always cried wolf in your institution or your housing unit, And one day they come up to you, go, my side's really hurting. Like, dude, your side's always hurting. You should have went to pill call, hit the rack. We'll see it tomorrow morning. And you didn't note anything. And all of a sudden the guy goes back to his rack, and you go over and you do your count 2 hours later, and he's passed out, vomit all of himself. And they find out when they take him over that he had a ruptured appendix and died as a result. The fact that he came to you and you had a duty or an obligation to advise the medical staff so that way he could be seen, and you were indifferent to that, you're like, I don't, it doesn't matter to me, you're always lying, you can be held civilly liable and criminally liable, so can the Department of Corrections. So that's the issue with deliberate indifference. Rhodes v. Chapman, 1981, double selling and crowding do not necessarily constitute cruel and unusual punishment. If it's continuous, where the state has mechanisms to go ahead and correct it, but they don't do it, then again we're moving to the deliberate indifference, and of course there could be issues there. Wilson v. Sider rather. Inmates must not only prove that prison conditions are objectively cruel and unusual, but show they existed because of deliberate indifference of prison officials, and that's what we just talked about a few seconds ago. And then deliberate indifference is the conscious or reckless disregard of the consequences of one's acts or omission. It entails something more than negligence, but is satisfied by something less than acts of, or omissions for the very purpose of causing harm, or with knowledge that harm may/will result. So again, as I said, doing something or not doing something when it falls within the scope of your responsibilities could be construed as deliberate indifference. And if something happens as a result of that, then you can be held liable. So I'll give you a real quick story about that happening to me. And I was very fortunate. I was a young officer at the time working in administrative segregation. And we had an inmate, her name was Patrick, and she used to come up to the cell doors and would, call your name constantly. And Mr. Ybarra, Mr. Ybarra, Mr. Ybarra. And she was just relentless. And I'm in there cleaning the tier. And finally, I just got tired, and I just put the damn mop down, and I walk over to our door. I'm like, what do you want? What do you want? And she goes, I'm hearing voices. And I was like, oh, my God. And now, when an inmate says that they're hearing voices, and you have to get a little more, I said, well, what are the voices saying? And she said, well, they're telling me to kill myself. All right, so when you have that situation, what I should have done was say, okay, let me see if I can get medical staff over here so that way they can assess you and do whatever we need to do, and you might be put on suicide watch or whatever. I had it up to here with her. This was a common occurrence for her. So what I did is I said, I asked her what the voices are saying. And she responded, they're telling me to kill myself. And I said, well, you know what? The next time they tell you to kill yourself, tell them fuck you. All right? And she started giggling, and then a couple other inmates that were right there started laughing too. And so I picked up my mop, and we kind of made a joke of it. And I'm like, okay, I solved the problem. Everyone's giggling, and it seems cool. She didn't seem to be decompensating and everything else. So I made that decision. Ultimately, if something would have happened to her, if she would have tried to take her own life, I could have been held responsible for that. So about 20 minutes later, I'm still finishing off, and then I hear it again, Mr. Ybarra, Mr. Ybarra, Mr. Ybarra. I'm like, oh my God. So I walk over to her cell door again. I'm like, what do you want, Patrick? She goes, I'm hearing voices. And I said, well, we went through this. I said, what are your voices saying? And she says, well, they're telling me to kill myself. And I said, well, did you tell them what I told you? And she goes, yes, I did. I said, okay, well, what happened? And she said, well, they said, fuck you too. And I mean, I fell out. I was dying. She started laughing again. Everyone else was laughing. And that was pretty much the end of it. And for the rest of the day, I didn't have to worry about her saying anything. It was funny. But again, I'm citing this as an example of what not to do. And I just happened to be lucky that nothing came of it. But that would be construed as deliberate indifference. Okay, moving on to number 7. 14th Amendment. All persons born or naturalized in the United States are subject to the jurisdiction thereof, or citizens of the United States and of the state wherein they reside. So no state shall make or enforce any law which shall abridge the privileges or immunities of citizens in the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction an equal protection of law. So remember, we said that you have the federal Constitution, which enumerates or codifies natural rights of all Americans. So state constitutions can be more lax and provide or codify more rights, but they can't codify less. They cannot take what is already granted by the United States Constitution. There are two clauses to the 14th Amendment specific to prisoners' rights. So the first one is procedural due process. You're going to see that again. And that's a constitutional guarantee that no agent or instrumentality of the government to arrest, prosecute, try, or punish any person without that due process, right? So they can't make a tribunal up and not have a series of events that they go through that are codified and already approved to show that the rights of an individual are taken into account. And that includes for administrative hearings too. So for the purposes of rule violations within the prisons, they still have to have a due process to deal with the allegations of inmate violations within a prison or within a jail. So equal protection is a constitutional guarantee that the law will be applied equally to all people without regard for individual characteristics. And these clauses were instituted to ensure the state cannot unilaterally segregate inmates or withdraw some good time credit without established minimal procedures to ensure due process. Some of these include written notice of charges, the right to present witnesses and documentation in defense, the right to an impartial hearing body, and the right to a written outcome of the hearing. So these are very similarly situated to due process rights that a person in the community has. And so essentially what they did is took some of those due process rights and moved them over to the administrative review process within the prison system. These rights were codified under case law in the following cases. So Lee v. Washington in 1968, law in Alabama used to separate white from black inmates in jails and prisons, and they found that was unconstitutional, obviously. Wolf v. McDonald, you may see that case again. 1974, due process procedures must be present when decisions are made concerning the discipline of an inmate in prison. And then Baxter v. Palomaggiano, and that is, although due process must be accorded, an inmate has no right to counsel during a disciplinary hearing. Now, that's specific, just FYI, that is specific to the institutions. Now, in community corrections, it's a little bit different, and especially here in California. All right, moving on to slide number 8. Congress, courts, and litigation alternatives. In 1996, Congress passed the Prison Litigation Reform Act, the PLRA. The PLRA has made it more difficult for incarcerated inmates to file civil rights lawsuits and for judges to make decisions affecting prison operations. Prison inmates now must utilize all administrative remedies prior to filing suit. They are prohibited from filing civil lawsuits if they have previously filed 3 lawsuits that were dismissed as frivolous. So these were mechanisms to basically minimize writs of habeas corpus, so that way legitimate issues with regard to either due process or violations, alleged violations by the state could be addressed. Basically, states were getting tired of having to file writs or having to research writs where an inmate said that they got a broken cookie and the person next to them didn't get a broken cookie when they went through the meal line. The Department of Corrections here in California utilizes what's called an inmate appeal process, where inmates can grieve decisions rendered by the Department of Corrections in a 602 appeal form. They've got a number of different steps with regard to the appeal process now, and we'll get into that a little bit later on. An ombudsman is a public official who has the authority to investigate and to make complaints against government officials, and in the California Department of Corrections will usually have at least one ombudsman in the institution, or they may have them if they have a mirrored institution. They may have one ombudsman for a section of institutions, and so inmates and staff will have access. They can go over there, and if there is a complaint, that's just another avenue that the inmate population has to have those complaints heard. It's an outside agency outside the Department of Corrections. Mediation is an intervention introduced by a third party to whom the parties in conflict submit their differences for resolution, and the decision is binding to both parties. So mediation is much like an agreement, right? So you have one person who's taking what both people want, and then they both come to an agreement. Another mechanism to reduce litigation is to provide legal assistance to inmate We don't do that here. It's believed by doing this, however, attorneys can advise inmates on the merit of complaints and thus discourage frivolous lawsuits. We don't use that here in California, but ultimately it could play out that way. That's again, but depending on the attorney, if it's private attorney, there's a possibility that they may want to do that because again, a lot of case law that goes all the way up to the Supreme Court has a lot to do with our criminal justice system, specifically prisons and jails. All right, moving to slide number 9, constitutional rights for probationers or parolees. So according to the late Justice Scalia, offenders committed to community corrections do not enjoy the absolute liberty that every law-abiding citizen enjoys. However, they do have conditional liberty dependent on observation of special restrictions. So remember we talked about conditions of release or conditions of parole or conditions of probation. There are some conditions that we don't have as law-abiding citizens, but they may have as a result of being on a supervised or monitored community corrections agency, being under that agency. So as an example, you and I have the right to come and go as we please, but a parolee or probationer may have a special condition that prohibits them from being out after dark as a result of behaviors that have a nexus to that restriction. So if the person was a burglar and they used to do all their crimes at night, then you could in fact put that condition on them that would limit their ability to be out at night unless it was for legitimate purposes, church, medical, had to get medical, that kind of stuff. And if they have a violation, then obviously they had to be held to account. So that's the limit that they would have with regard to their liberty versus the security of the public. So there is some case law that talks about that. Pennsylvania Board of Probation and Parole v. Scott in 1998, the court ruled the evidence that would be borne by the exclusionary rule can be used in parole revocation proceedings. So we're talking about exclusionary rule would be evidence that's secured through an illegal search, right? However, we do know that probation and parole, because they maintain a type of custody of the offender, that most of them can be searched, especially here in California. Parolees and probationers can be searched with or without a warrant, with or without cause, day or night. And so it's not required that a warrant happens. We'll get more into parole and probation searches later on in this course, but suffice to say, they actually have a tapering or tailored rights with regard to that. Sampson v. California, 2006, court ruled that warrantless search by a peace officer who is not the supervising officer does not violate the exclusionary rule because, by definition, parolees are still in the legal custody of the state or that controlling agency, and thus have reduced privacy rights because a parolee signs conditions of parole, which advise them that they are subject to warrantless searches. In the case of probation and parole revocation proceedings, Memphis v. Ray in 1967, the court determined that a probationer had a right to counsel in a revocation proceeding and a sentencing hearing before a deferred prison sentence could be imposed. And remember, we talked about the probation and parole revocation proceedings are significantly different than their counterparts inside the jail and prison. So as you can see, in Memphis v. Ray, probationer did have a right to counsel, but if they were talking about being inside the prison or being inside prison, they would not have a right to counsel. All right, in this next one, you'll see again Morrissey v. Brewer. The court ruled that parolees facing revocation must be given due process. The court required a 2-step revocation process, and that mimics what our current courtroom process is. So, first step determines whether or not probable cause exists for that violation, and the next step, the parolee is afforded due process rights. In the second step, the parolee must receive a notice of charges and to disclose evidence of that violation. So we have a fact-finding phase, and then the hearing/sentencing phase. So it pretty much mimics what the courtroom process is, and that's what we do today with our inmates. As well as with regard to our parolees, they actually do go through a courtroom process now. That's very, very similarly situated too, and we'll get more into that a little bit later on in the course. All right, and the last slide on Chapter 5, correctional personnel. So the following steps, rules that correctional workers employ to protect themselves from Section 1983, which is deliberate indifference suits, and that's for the federal government. These are federal employees, okay? So 5 rules were established by the Federal Bureaus of Prison. So the prison said that in order for people to not be found individually liable, they have to do these things if you're working for the federal government. Follow all written policies, procedures, and instructions and orders from the supervisor. Obtain good training. Staff members need to know their area of performance that exposes them to the most liability. Become familiar with the law directly affecting the job to ensure good defense when being sued, find a good mentor, and keep good records. And that really does make sense for pretty much every single job that you have. And I can tell you from when you start with the Department of Corrections, after you go through your academy, and then going through your probationary period and everything else. But when you get your first assignment, the first thing you're going to wind up doing after you collect all your equipment is you're going to review your post orders. Every single post in every single prison has a post order rule. So essentially, it's a step-by-step guide of things that you're going to have to do, responsibilities that you have throughout the shift. So you read through that, and you'll have to sign your post orders, indicating you've read and acknowledged your responsibilities and duties on that specific post. And then, of course, you'll wind up getting on-the-job training by seasoned officers as well as your supervisory staff. All right, this concludes the lecture portion for Chapter 5, and we're going to move on now to Chapter 6. Let me slide this over, and we'll go from there. So who is in prison? The idea behind the criminal justice system is that it's a prescribed process that looks at the degree of seriousness of the crime and of the circumstances surrounding the offender to determine the type and the degree of punishment that's appropriate. So you can look at the criminal justice system as a stage filtering process. So the idea here is you have 1,000 crimes, half of those crimes go unreported, and 80% of the other 500 crimes go unsolved. So that leaves 100 people arrested of the original 1,000. Not a lot, right? So of those 100 people, after going through the prosecutorial discretion stage, and we learned about that, or if you haven't been in my Crim 4 class, you will learn about that. So you'll go through the prosecutorial discretion stage, the court, and ultimately you'll get the incarceration rate will be about 5 juveniles and 18 adults out of that original 1,000 crimes. That's not a lot, folks. That's not a lot. So it kind of goes to show you how many crimes actually suffer a severe penalty versus ones that are actually let off and diverted or whatever in the criminal justice system. The text poses a question: what are people who break the law like? And so to answer that, people that break the law from all walks of life, from the affluent, very wealthy, intelligent, to the financially desperate, socially, economically disadvantaged, to the confident idiot, all of them, and there's a wide range. Now, the bulk of them is in the low end area, the confident idiot and the socially, economically disadvantaged. Those are the ones that make up the bulk. But that incarceration and engaging in criminal behavior is not just a province of the poor, right? People of all walks of life engage. And there could be an argument, and a legitimate argument, that individuals who are affluent will generally commit crime that affects a higher percentage or a larger percentage of people than individuals who commit low-level or street crime. And I'm not talking about seriousness here, but we're talking about how much damage is actually done to the community as a whole, right? So if we have one person who's going and stealing stuff from a house, yeah, he's going to affect a few homes. But if you have somebody who engaged in malfeasance, say for instance they were a an accountant, and they were working for an accounting firm that dealt with pensions, and they embezzled a bunch of money, and all these people lost their pensions as a result. We can see that one crime could affect thousands of people. So, like I said, the argument could be made that individuals who are affluent and wealthy and knowledgeable, that engage in criminal endeavors, can and oftentimes do affect a larger portion of society than low-level street criminals. And I'm saying generally, not all the time. All right. Number 2, types of inmates, situational versus career criminal. An inmate who is considered situational is a person who, in a particular set of circumstances, has violated the law but is not given a criminal behavior under normal circumstances and is unlikely to repeat the offense. And a perfect example of that would be a crime of passion, right? So you've worked a 12-hour shift, you're tired, you come home, you open the door to your house, and what do you see? Another guy in your bed with your significant other, right? And all of a sudden, it's not one of those things you're going to, that you plan for. Your emotions, they ramp up really quick. You engage in that criminal behavior, and it was a situational engagement. The study about situational criminal behavior has described that a person confronts a problem requiring some type of action. That action violated criminal statutes. The person was caught and given a criminal status, an inmate or convict, and until the time of the offense, the person was committed to lawfulness and was indistinguishable from other people, right? So, they did what they were supposed to do until that circumstances. A career criminal, on the other hand, is a person who sees crime as a way to earn a living. In the course of their criminal career, they have numerous contacts with law enforcement, and they view these contacts and the criminal sanctions that result, imprisonment, punishments, whatever, as a normal part of life. And they use these setbacks in their criminality to adjust and fine-tune their craft. And generally, it doesn't really work, because when they adjust and fine-tune, they're normally getting their information from the same people who also got caught. So, and it happens quite a bit. You get people who are greedy. I had a couple of people. One woman had decided she was going to go ahead and embezzle money, and had a really good thing going, and eventually got caught because she got greedy, and that's one of these career criminal type people. All right, number 3, sex offenders. So sex crimes are sexual acts prohibited by law, such as rape, child molestation, prostitution, which are motivated by economic, psychological, and or situational reasons. You may see it again. The definition of rape has over time been reconceptualized not entirely as a sex crime, but as a personal assault. And according to the Uniform Crime Report, UCR, we learned in Crim 1 what that was, rape has been newly redefined as penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. And that's according to UCR. That's a federal definition of what rape is. Very few crimes invoke the ire, which is the anger, of the public more than child molestation. As many as 90% of the people convicted of these crimes were molested as children. 20% of the people are over 50 years of age. And contrary to mainstream belief, most people who commit sex crimes against children have an established relationship with their victim. And the reason why that is because anytime you have an established relationship, even for non-sex crimes, because there is emotional tissue between the victim and the perpetrator, it's much harder for the victim to want to get the perpetrator in trouble, and so they're more willing to absorb some of that responsibility of that crime. They're like, well, if I hadn't dressed like this, or I hadn't acted like this, or I hadn't said this, or I hadn't looked like this, then maybe it wouldn't have happened to me. And so they start assuming some of the responsibility. Sex crime of prostitution is usually motivated by economic reasons more than psychological. Society has split feelings regarding this public order crime. For those of you who were in my Crim 1 class, public order crime is crime that actually has no victim, so they're crimes against society based on society's moral standing of that time. On one hand, there's a legitimate public concern for the danger to society as a result of sexually transmitted diseases and violence that accompany prostitution generally. However, given that there's no true victim beyond society, arguments have been made that prostitution should be legalized, and its legalization would reduce or eliminate the above-mentioned dangers. And again, depending on where you land on the spectrum, you could be either or. So a public order crime that we just talked about would be like prostitution, drug use, gambling, anything where there really is no victim except for society. So that's the distinction between the two. All right, slide number 4. Substance abusers. So substance abuse refers to the disruption of normal living patterns by the chronic and excessive use of either alcohol and or legal/illegal controlled substances to the extent that social health and behavior problems develop, often leading to criminal behavior. So chronic means long-term, right? So if you hear the term chronic, it's long-term, it's over a long period of time. If you hear acute, that means it's happening now in large amounts, right? It's like really bad at that point in time. So chronic and acute. The National Center on Addiction and Substance Abuse completed a study that found 4 out of 5 people who are incarcerated in both jails and prisons were under the influence of either alcohol or drugs when they committed their crimes. Further, they resorted to property crimes to fund their habit and or had a history of drug and alcohol abuse that led them to commit crimes. Recently, DOCs have recognized that drug and alcohol abusers are compulsive, which means that they do things without thinking about it. It's basically become habit, and that their behavior is likely to be repeated while in custody or upon release from custody. As such, many departments have enlisted drug and alcohol treatment services in lieu of prison or jail for low-level offenders. Those alcohol and drug addicts that are incarcerated, they are placed into programs within the jails or prisons in an effort to break the cycle of addiction. And so the reason why they do these programs at prisons and jails now, and they're really advocating for them, is because you have a captured audience, right? We've learned that when they're out of custody and on their own, it requires a much higher level of commitment by the person to engage in these programs. People don't want to go to a drug treatment program. They ultimately decide that they need to go to a drug treatment program to learn the skills necessary so that way they can refrain from that behavior. But when they're in custody, they have to. They're a captured audience, right? So the drug treatment programs inside of prisons versus ones outside, while they are similarly situated, they utilize different processes to accomplish the same thing. Because ones inside, since they're captured, they're going to be a little bit less reluctant, or a little more reluctant rather, to engage in these programs because they're there by force, versus ones that are outside, generally speaking, there's some kind of sanction over their head, that's why they're engaging in it, or they decide they want to go because they feel they need to go now, and they're ultimately ready to make some changes in their lives. All right. Number 5, inmates with mental illness or developmental disability. So mental illness is defined as a health condition involving thinking, emotion, and or behavior that can cause problems in social, work, and family activities. So it's different between developmental disabilities, which are disabilities that that deal with actual brain functioning, right? So it's estimated that 800,000 people in the United States prisons and approximately 500,000 in jails suffer from some type of mental health problem. We learned that we have about 1.2 or 1.7 million people. So if 800,000 of that 1.7 million have some kind of mental health problem, you can see that we have a significant community of mental health issues or a significant problem that has to deal with mental health. So here in California, there was 3 court cases that had to deal with equal access specific to inmates with different types of disabilities. One of them that we're going to discuss right now is Coleman v. Schwarzenegger in 1990, and that addressed treatment and equal access to programs for inmates with mental health. So these programs included psychotropic medication issuance, programs tailored for inmates with mental health issues, and to establish deinstitutional procedures, which are the processes to release an inmate with mental health issues into the community. So the Department of Corrections had to start adopting these because they were ordered by the court that they had to do that based off of the facts that a significant amount of the population had mental health issues and were documented with mental health issues. All Under Clark v. Wilson, very similar to Coleman v. Schwarzenegger, the Supreme Court ordered the Department of Corrections to provide equal access to inmates with documented developmental disability. So developmental disability, sometimes referred to as a learning disability, is the inability of a person to learn or develop skills at the same rate other people do because of an actual physical problem with the brain. Many of these people require special needs and have higher victimization issues while in custody. This would be somebody who's autistic and that kind of stuff. So believe it or not, there's not a lot of these people, but there are some. And as a result of having these people in the DOC, the California Department of Corrections was ordered by the court to ensure that there's programs that are similar to the ones in Coleman v. Schwarzenegger to address these individuals, and especially the issues with regard to victimization. And so they classify these individuals, and this classification lets staff know the different types of things that they have to do within the housing unit, when they're in the yard, such as prompting or maintaining a more of a constant vigil on these individuals because of their mental problems. Okay, inmates with communicable diseases. So the HIPAA, which is Health Insurance Portability and Accountability Act, privacy rule creates national standards to protect individuals to include inmates, medical records, and personal health information. These protections make it difficult for correctional staff, however, to accurately assess how many inmates have a type of communicable disease. So in 2010, 4,344 inmates in the U.S. jails and prisons were diagnosed with AIDS, and over 20,000 were positive for HIV. This is approximately 1.3% of the total incarcerated population. So it's a significant amount of people, right? We learned that that's a significant amount of people. And given the fact that they have a very risky lifestyle in the first place, they share intravenous needles when they do their dope. They are quite a bit more promiscuous, even in prisons and jails. I'm sure you guys know that they do engage in sexual concourse with each other, sometimes of their own volition, sometimes not, but they do that. Most HIV-positive inmates in California are housed in general population. However, if and when the disease progresses to AIDS, they're transferred to a correctional medical facility, and the costs associated with providing this treatment can range from about $50,000 to $300,000 annually, the higher end of the scale for those inmates who are in the acute stages of the disease. Now, the Department of Corrections, like I said, they cannot say that a person has AIDS, but what we do is we note that every single individual, we make the assumption that every single individual within the Department of Corrections does have a communicable disease, and thus at all times, officers and free staff alike practice universal precautions, and we'll get into what the idea of universal precautions are later on in the chapters that are going to be upcoming. All right, elderly, long-termer, and military inmates. So as of 2015, U.S. prisons and jails hold over 121,000 inmates over 55 years of age. If the current trend continues, there may be over 400,000 inmates, elderly inmates in prisons and jails, and the evidence suggests that elderly inmates pose a lowest risk to recidivate, which means go back to prison. As such, many corrections departments are looking to release these inmates to parole. However, this also poses issues for parole supervision in that most of these inmates have limited community survival skills because of the time that they've been in custody, right? For those of you who saw the movie Shawshank Redemption, that illustrates it pretty well, that a lot of these men and women that have been in for a long time, for decades, there's been so many changes with regard to technology and processes in the community that they don't fit in very well. A long-termer is an inmate who serves a lengthy period of incarceration in prison, usually over 10 years before his or her first release date. Most long-term offenders have been convicted of violent crimes and or drug distribution and sales. And I can tell you that I have found most long-term inmates, when we get them on parole, have a better chance of success through their parole period than the short-term inmates. And that's just based off of the idea that they have been in for such a long time that they are less, that long time has an actual specific deterrence impact. That long period of incarceration has a specific deterrence impact, and they legitimately don't want to go back because they've already spent such a long time of their life there, right? So if you spend a year and a half in prison, they're like, well, I was just a year and a half, not a big deal. I got all my life to keep going. But if you spend 10 plus, and say you spent 15 years, you went in when you were 20, you come out when you're 35, you've missed your 20s. You've missed your party time. You're deep into your responsibility time, and you have to start from ground zero now. So you don't get a lot of time before you get to your retirement age. And most of these guys recognize that, and ladies, and so they're a little bit less likely to re-engage in that criminal behavior. Not to say that they don't. I've had a couple of guys who got out who were immediately doing dope and partying and having a good time, and they've been in for like 18 years. I was like, man, you guys are crazy. Of course, we reincarcerated them and let them continue because they weren't ready. So they had to go back. But by and large, most of the parolees that I had that had served a significant period of time, they were the ones that actually did real well. It's estimated that about 8% of incarcerated inmates have prior military service. This equates to about 200,000 veterans behind bars and over 500,000 veterans on probation or parole. Many of these veterans suffer mental health issues as a result of their military experience, especially now because we're in a period post-war. So when I went in, I was in the military. It was during the Cold War, and so we didn't actually have any actual combat. But now, obviously, a lot of the veterans that have come out have actually been in combat. They also pose a higher security risk to correctional staff in that many of them have special combat training, and they actually engaged in that to include hand-to-hand combat and evasion techniques, which does make it a little bit more difficult to deal with these individuals if they decide that they want to rebel and they want to fight, and they have good organizational skills. So we have to be very, very cautious and cognizant of that when we're going through our classification, both within the institution as well as on probation and parole. So bear that in mind. Okay, last slide. Classification of inmates. According to the CDCR, classification is defined as a continual diagnostic and prescriptive process that involves a systematic study of inmates' case factors throughout their commitment to the Department of Corrections. Well, what the hell does that mean? Well, let's break it down. A continual diagnostic and prescriptive process. So if it's continually diagnostic, that means we're looking at it over and over again, right? So the classification of an individual, when they come in, they have their initial classification, and their behavior while they're inside is going to determine their levels as well as where they're going to wind up working and programming within that spectrum of the institution. A prescriptive process means that process is set in stone. Remember we talked about regulations? That process doesn't change, so the inmates know they got a baseline of what they need to do. Staff knows what they have to do. And when it comes to the classification of these inmates, there are certain things that have to be met. There's certain reviews that have to be met. So continual diagnostic and prescriptive process that involves a systematic study of an inmate's case factors. So systematic study means what we do is we take an inmate's risk and needs that we look at with regard to behavioral, educational, social data, their commitment offense, circumstances of previous criminal history, and we convert that information to a numerical point system, and that numerical point system allows us to place them in levels where a level 1 will be a low-level inmate that would require the least amount of supervision, all the way up to a level 4, which would be the high-level inmate that would require more concentrated supervision. And that happens throughout their commitment to the Department of Corrections, to include parole. So the reasoning behind classification that is it allows corrections departments to manage the inmate population by placing them into the lowest level institutional setting without jeopardizing institutional safety, the inmate's well-being, and public safety. And why do you want to do that? Well, it goes, what it boils down to is money, right? Anytime that we can put an inmate or a parolee in the lowest level supervision setting means that we don't have to spend as much money, taxpayer dollars, in monitoring this population, right? If I know that these people have maintained stable employment, gainful employment, stable residence, haven't had any major violations, we can reduce their supervision level so I can concentrate my resources on parolees that require that. Classification reviews social commitment data, behavioral, and educational data, which allows correctional staff to generate a report referred to as a risk needs report. This report identifies programs and services that an inmate may need while in custody, as well as identifies security concerns that the inmates will pose. This report is then converted to a numerical scale, and we just talked about that, sometimes referred to as a classification score. And this score is reviewed on a continual basis, usually annually, but sometimes can be more frequent, again, based off of the inmate's behavior, either negative or positive, and throughout their commitment to the Department of Corrections, and again, once they parole. So that's a very brief overview of classification. We're going to wind up delving a little bit more into what classification is later on in some of the other chapters. But this concludes the lecture for Chapter 6, and we've covered all 3 of the chapters within this this video. Again, if there's any questions, issues, comments, or concerns with regard to the content, feel free to give me a call, email, or text, and I'll be happy to answer it. And till next time, we'll see you again in Chapter 7. Thank you much, and have a great day.